I stand on my 2 feet. I'm in my proper person. I'm sovereign. I am man. The flesh lives. The blood flows. I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case.
That would be denied.
Along with the officer and sergeant who are already going to be getting sued. There's no need to add you as well.
Any threats to sue me or to take any action against me, I can't be swayed by that. So
it's not a threat. It's just what it is.
All right, everyone. Today, we're covering a courtroom encounter involving a self-identified sovereign citizen whose arguments immediately set this hearing apart from arrest. From the very start, the defendant introduces himself in an unusual way, insisting on repeatedly stating that he is a living man, emphasizing his physical presence rather than addressing the legal issues before the court. While those statements may sound meaningful to him, they don't carry legal weight in a courtroom setting. Courts operate on established law, not personal declarations of existence or identity. Still, he continues leaning heavily into this language, clearly believing it strengthens his position, even as the judge patiently allows him to speak. Things escalate further when the defendant suggests taking legal action against the judge herself. That kind of statement is especially serious, as courts view threats or attempts to intimidate judges as inappropriate and potentially consequential. Judges are protected in their role, and comments like these rarely help a defendant's case. In fact, they often make matters worse. This hearing quickly becomes one of those moments where you truly have to watch to understand how far the arguments go. The exchange highlights just how disconnected sovereign citizen theories can be when they collide with real courtroom procedure. The contrast between the defendant's beliefs and the legal reality creates a tense and unforgettable situation. I'm curious to hear your thoughts as this unfolds. What do you make of the arguments being presented here, and how do you think the judge should respond to them? Drop your opinions in the comments, and let's dive into hearing to see how this unusual courtroom moment plays out.
Go ahead and have a seat, please. His rights at arraignment.
My honor. So, for the record, I've made this special visitation under duress pertaining to the matters of Jonathan Troy, favor Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status, and so I ask you, ma'am, what is your name, what is your nationality, and what is your status?
I'm Judge Grant. I am a citizen, and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months, and then there was also a driving violation. Wheels were off the roadway. Last 2 are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status, and so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued, it would just add to that. And I don't think that you need to go that route.
While I review this incident report. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is practicing bench from the
Unless you
law.
want to enter a plea of guilty, today there'll be a plea of not guilty. I understand you are objecting.
Ma'am, I
to-
object. I challenge the jurisdiction. Jurisdiction has not been proven.
The defendant insists that jurisdiction has never been proven, yet the situation around him tells a very different story. He's seated in custody, wearing standard jail attire, and physically present before the court. Those facts alone strongly indicate that the state's authority is already established. Jurisdiction isn't something that exists only when someone agrees with it. It exists because the law says it does. His arguments give the impression of someone repeating phrases they've heard elsewhere without fully understanding how they apply in a real courtroom. He speaks as though he's about to reveal some major legal insight, but the points he raises don't align with actual legal standards or procedure. Instead of presenting evidence or legal authority, he relies on broad statements that don't hold up under scrutiny. What's noticeable is how emotionally charged his delivery becomes. Rather than calmly supporting his claims, he appears frustrated and overwhelmed, which only weakens his position. Courts aren't persuaded by intensity or confidence alone. They require facts, precedent, and clear legal reasoning at this stage. The burden isn't on the judge to prove jurisdiction exists. It's already presumed under the law. If a defendant wants to challenge it, they must provide a valid legal basis for doing so. Simply declaring that jurisdiction is invalid isn't enough, especially when court record and circumstances clearly indicate otherwise. This may not be the most extreme sovereign citizen argument we've seen, but it does reflect a familiar pattern: arriving unprepared, relying on scripted phrases, and expecting those phrases to override established law. So far, that strategy isn't helping him out. What's your take on this defendant? Do you think he genuinely believes these arguments will work? Or does it sound like he's repeating ideas without fully understanding them? Share your thoughts in the comments, and let's jump back into the hearing to see how the judge responds next.
Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but it looks like you have a driver's license that recently expired.
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating
Again,
laws.
I was not driving. Again, I have rights.
You were behind.
And my rights were violated.
Labeling.
My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
Sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have some a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him.
Based on his attitude and behavior in court, it's hard to imagine this defendant taking the situation seriously if he's released today. His lack of concern for the process suggests a pattern of ignoring rules and dismissing responsibility, which raises valid concerns about whether he will comply with court orders moving forward. When someone shows this level of resistance inside the courtroom, it naturally makes judges cautious about what might happen outside of it. What stands out most is how casually he treats serious allegations. Instead of showing awareness or accountability, he appears disconnected from the consequences of his actions. That kind of mindset is often what leads people to repeatedly find themselves back in court, not because they don't know the rules, but because they choose not to respect them. Cases like this create a difficult challenge to the justice system. Judges aren't just deciding guilt or innocence. They're also weighing public safety, compliance, and the likelihood that a defendant will follow the law if given another chance. When someone openly rejects authority and legal structure, it limits the court's options. This brings up a broader question. How should the system handle individuals who consistently refuse to engage with the process in good faith? Longer supervision, stricter conditions, or mandatory legal guidance are often considered, not as punishment alone, but as tools to encourage accountability and prevent repeat issues that I'm curious what you think. Should courts respond more firmly in situations like this? Or is there a better approach to deal with defendants who repeatedly reject legal authority? Share your thoughts in the comments. And let's jump back into the video to see how the judge ultimately handles this case.
I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also, indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle Municipal case and see when he's next scheduled to appear.
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Humiliates Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot. And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the Seattle
Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
It's not a threat. It's just what it is.
School. It's honestly hard to believe what we just heard. The defendant openly suggests that the judge herself could be added to a lawsuit if she doesn't release him from custody. That kind of statement immediately crosses a serious line. Courts view comments like this not as legal arguments, but as attempt to pressure or intimidate the judicial process. And that's something judges take very seriously. What's surprising is how calmly the judge responds in that moment, rather than reacting emotionally or escalating the situation. She maintains control of the courtroom and keeps the focus on procedure. That restraint is intentional. Judges are trained to separate provocation from process, even when a defendant says something that would normally warrant an immediate correction. Still, it raises an important point. While everyone has a right to speak and defend themselves in court, there are clear boundaries. Threatening legal action against a judge as leverage is not a valid strategy, and it can easily backfire. Statements like that often become part of the record and can influence how the court views a defendant's credibility and intentions so far. The judge has handled the situation with notable composure. She's allowed the defendant to speak, corrected misinformation, and avoided unnecessary confrontation. The question now is whether that calm approach is the most effective way forward, or if a firmer response would better reinforce the seriousness of the moment. What do you think? Has the judge struck the right balance between patience and authority? Or should she have addressed that comment more forcefully right away? Share your thoughts in the comments. And let's dive back in as we move toward the verdict.
Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
when are you setting that court date, Miss?
Required by the Department of Licensing. You will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges that have significant consequences for you. So it's in your best interest to have counsel.
Again, I stand on my own 2 feet. I do not need to be represented by anybody. I present myself. Sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights. And I do not need to be represented by anybody.
All right. The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be...
We want to try for next Wednesday or even the week after that.
Well, next Wednesday's a holiday, so the 18th, which is pretty full. So I was going to set this on June 24th. That's 2 weeks out.
So for the record, you have not established status. You have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench.
Sign for your next court date.
You're asking me to sign something that you pleaded for me. Is that
Yes,
correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said
I'm
yes, you
noting that
pleaded
I
for
found
me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice, and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I
piece
do
of
not
paper
understand how
with
you
the
can practice
document?
law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty, so on your behalf, I'm entering a not guilty plea.
So, correct,
We
you
cannot-
are pleading for me,
There's
correct?
two pleas.
And if you
not
plead
guilty
for me,
or
you're
guilty.
practicing law from the bench. You cannot practice law from the bench, so I object.
Right.
You're-
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay?
Jennifer
Okay.
Grant, you will be
Okay.
taken further.
Well, that definitely didn't go the way he thought it would. You can tell the defendant genuinely believed he was about to walk right out of that courtroom. But reality hit hard. Courts don't reward delays, scripted arguments, or repeated claims of no jurisdiction. And once again, that strategy completely fell apart. This hearing was chaotic from the very beginning. The defendant relied almost entirely on recycled sovereign citizen talking points, especially the jurisdiction argument, which never holds up in real courtrooms. It's a tactic we see over and over again. Stalling, talking in circles, hoping the process itself somehow collapses. But it simply doesn't work that I asked the judge. Her approach is interesting. Some might say she should have been stricter sooner, while others might argue she was playing the long game, allowing the defendant enough room to speak. So the record clearly shows his lack of legal grounding. Sometimes, letting someone fully expose their own arguments is more effective than shutting them down immediately. Either way, this hearing was a mess, and it was clear from the outcome that the court was not persuaded in the slightest. I'm definitely looking forward to finding and posting part 2 of this case, because something tells me the story is far from over. Now I want to hear from you. You think the judge should have stepped in more aggressively, or was she smart to let the defendant talk himself into a corner? Drop your thoughts in the comments. If you enjoy wild courtroom moments like this, make sure to like and subscribe. I post new content every single day. Thanks for watching, and I'll see you in the next one.